would gladly tell you the significant roles that animals play in the lives of their families. In fact, it's not a stretch to say that many people consider their animals family. And while the relationship stays intact in the family, that results in a beautiful picture. But what if there's a split and people separate or divorce? Across Canada, overwhelmingly, the laws that dictate how animals are treated during separation and divorce proceedings have been consistent. Animals are treated like property, not unlike that of a table or a couch. If you're the one who bought it, then you're the one who owns it. But a recent change to the Family Law Act in British Columbia has taken a different approach, an approach that could very well permeate across the country. According to the new section of the British Columbia legislation on companion animals, pets will be seen as family members and no longer just simply awarded to the spouse who purchased or adopted the animal. The BC courts will take a more holistic approach. In the case of PMZ versus DJT, a 2023 case, the judge laid out the factors for courts to consider when determining ownership of a family dog. Factors that include the circumstances in which the animal was acquired, the extent to which each spouse cared for the animal, any history of family violence, the risk of family violence, and a spouse's cruelty or threat of cruelty towards the animal. The relationship that a child had with the animal is also considered, as well as the willingness and ability of each spouse to care for the basic needs of the animal. The BC government says that it was public feedback that inspired the change, making British Columbia the first province to treat animals like family. In the case of Atwal v. Randhawa, a later 2023 case, it was the first case where the factors in the proposed amendments were applied. In that case, the judge stated, "Accordingly, I decline Miss Atwal's application to transfer the dog entirely to her." Instead, the judge laid down terms not unlike those seen when dealing with children of divorce. The judge stated, "Each party shall have the dog's companionship for 1 month durations on an alternating basis, thereby imposing an equal timeshare." The judge went on, "All exchanges of the dog shall occur in British Columbia at the Surrey RCMP station, similar to what happens when kids are exchanged, particularly in high conflict situation." The judge went further. Miss Atwal will not be permitted to travel with the dog outside the Lower Mainland, thereby the judge imposing geographical boundaries. And finally, the judge stated, Mr. Randhawa will not be permitted to travel with the dog outside the municipal Seattle area, thereby imposing travel restrictions. The BC decision has been widely celebrated by pet lovers in that province and has dog lovers across the country hopeful that this approach will also be available to them if they face circumstances in their home provinces that are similar to this divorce proceeding.